Peace, everyone. Let me just make sure this is straight. Smoke detector. Alright. Cool. Peace. So today, I want to talk about. Estate planning. So I have available on the website, riseofthemortals.org, a consultation offering discussing estate planning and how to create generational wealth within 2 generations. So it's in connection to my trust law series, and you can kind of see the little advertisement right here across the screen. It's connected to my trust law series in a way that is basically the culminating um, event piece to the trust law series. And I've done a video on YouTube already, on this YouTube channel already, about how my parents and I fought against a foreclosure using trust law and the information that I have in my trust law series, trust law 101 through 104, and then trust law 105 is free on the website regarding from Black Wall Street to the ghetto. Um, so now I'm offering a chance for Morris to speak to me and consult on just ideas about estate planning and how it affects people. And I have some things ready to show you. Hold on, let me do this. Let me move the camera. Let me do this. Let me know if you can see that in the chat. I'll do this right here. So this document right here, and I talked about this live with my parents. It's on the YouTube channel. But this is a trust document that it was a declaration of trust that we filed with the recorder of deeds, and I talk about this more in detail in the video I did with my parents regarding the whole foreclosure process. I think it started around either 2018 or 2019, a few months before Christmas. So you already know how emotionally discouraging that is to get this foreclosure notice right before the holidays, and how we basically was fighting it. We were fighting it since then. And then when I was in jail, they went ahead with the foreclosure process. Well, no, when I was in jail, they went forward with having a court hearing regarding the reversal of the foreclosure without me. But they had foreclosed, I think, in 2020 maybe, and they had told my mom to get out the house that October. And there was a few more that ended up showing up with me to my mom's house where we put private property signs, etc., etc., etc. I talk about all of that in detail in the video. But when it comes to estate planning and trust law, I'm not just there's a lot of Moors out there that will do flashy videos that look good and stuff like that, and they talk really good. They sound nice. They sound like they know what they're talking about, but they don't have any practical application. So I'm not trying to fool anyone with, camera edits and whooshing and zooming in, and I don't want to appeal to I'm not trying to sell people something. You know what I'm saying? I'm not selling you an idea or something that I haven't personally done, if that makes sense. All right, so this is all this stuff can be looked up. None of it is like super hidden private information. But we see here a declaration of trust because obviously when you create a trust, and there's two types of trust, and I talk about this in the consultation. When you get the consultation from the website Rise of the Moors, you get an attached Word document, and I go into detail what a living, a revocable trust is and irrevocable trust is, and it basically boils down to a revocable trust. The word revoke means to take away, so a revocable trust can be taken away, and an irrevocable trust cannot be taken away, and a trust only becomes irrevocable when the grantor dies, and the intent of the trust is to become perpetual. So if, as an example, here's an example of a revocable trust. I say, hey, to one of the viewers watching, I will, let's create a document where you watch my property while I'm gone for the month. Right? Let's say I'm going on a vacation and I want you to take care of my property. Uh, in the document, I'll specify that I'm only going to be leaving for 30 days. So my house is only in your trust for 30 days. That is an example of a trust that is revocable. Let's say I come back 15 days early. I can terminate that trust because I'm the grantor, I'm the creator of it. But let's say there's a monetary amount. Let's say I agreed to pay you $20 or whatever a day. And we may not necessarily want someone to know about our agreement. So as opposed to posting the agreement of the trust, we'll file a declaration of trust saying that on this date we had an agreement on this specific document, and we could even put some type of number uh, within the declaration of trust that points to that document. So that way, if the document ever gets brought up in question, according to the four corner rule, the original actual trust will be brought forward, right? So that's how you can keep things separate as far as a private side and a public side. All right, so there are ways to keep things private within trust and to also file trust on the record. That's what a declaration of trust is for, right? So that's an example of a revocable trust. An irrevocable trust is something that cannot be taken away. So let's say I do have a trust for my children, and in that document I leave everything to them. Well, as long as I'm alive, I'm the administrator of that trust until I become incapacitated in some form or fashion, whether it's through death or imprisonment or, hospitalized for whatever reason. So long as I'm alive, I'm the administrator of that trust. The moment I become incapacitated or die, that trust is no longer revocable. So it turns into an irrevocable trust. And hopefully, I would have given my children the necessary knowledge that they need to maintain this, to maintain the property, to maintain the administrative uh, requirements to keep up the trust as far as recording things. So that way the trust will remain in perpetuity. But that is all predicated on, and more detail will be given in the consultation. That's all predicated on what we do as parents, and or if you're a grandparent, whatever you are, someone planning to make a trust. The success of that trust is based on how detailed you are, and it could be as short, general, specific, or lengthy as you want it to be. Um, but some things that are necessary for a trust is, one, there has to be a grantor, meaning someone who created it. There has to be an administrator, who is the person that is taking care of the trust, who's actually administrating the affairs of the trust, whatever is stipulated in it. And then there has to be a beneficiary. Now, the grantor can either be the grantor and the trustee, or the grantor and the beneficiary. They can't be all three, right? Because now you're getting into the realm of greed. So, as an example, my children, one's not even here yet, he's still in the womb, and my daughter, they are the beneficiaries, right? I'm the trustee and the grantor. So I'm doing both jobs of, I created it and I'm administrating it until they're of age. Once they become of age and I die, now they're the administrator. So now the position of grantor no longer exists because I'm dead, or I will be dead, right? So now my who you know according to Islam, trusts are supposed to be, or inheritance are supposed to be given in a certain way. But whichever one of my heirs is competent enough to administratively handle the affairs will be the trustee. And then, both of my children's children, so my grandchildren, will be the beneficiaries once I'm gone. And then it will just be passed down in perpetuity until something happens. Hopefully, nothing will happen though. And within trust, it's best to stipulate, like in my trust that I have stipulations on who can become a trustee. One of the requirements is you have to be of my bloodline or actually married into my bloodline and have children. Then you qualify for a position as a trustee. So hopefully my children won't do the boyfriend and girlfriend thing, but if I'm not around and that happens, their quote unquote boyfriend and girlfriend won't even be eligible to be to administer anything that I own because they don't meet the qualifications, right? So those are two examples, or those are the examples of a revocable trust and a irrevocable trust. So this example that you see on the screen, in the actual full-length document that I believe we went over on the original live that I did with my parents, you see that this document right here is a revocable trust. It was for, and you'll see right here, right above the receipt, where it says for the specific purpose of. So right under my name, where it's highlighted in blue, it says for the specific purpose of. So now this trust is clearly specifying and expressing what my job was as a trustee, and it wasn't permanent. It was limited to this specific issue. So here's a perfect example of a revocable trust, right? And on it, I have underlined specific information because you'll see that on the documents that I show right after this. But one, you see docket number 002266932, book number 12359, and page number 34. And then you have the positions I talked about earlier. You have the grantor being my mother, but I just show you the name of the trust in purple. And then you have the administrator, which was me. And then the beneficiary was my parents. Well, I mean, I also benefited too, but it wasn't just for me, it was for my entire estate. And I go over what the word, if you don't know what any of these words mean, I go over these things in my trust law series, and this is why I recommend that if you want a consultation with me, that you view or you purchase the trust law series first. And I also have a trust, how to create a trust video free on the YouTube channel, where I go over a lot of basically everything. So I won't, in this video, I'll try not to go into detail into every little thing. But yeah, is administrator and trustee synonymous in application of the trust structure? Yes, it is. Yes, by definition, yes. Because the word trustee is the person who's administering the trust. So they are the administrator, yes. Great question. So yeah, my name's in blue. The name of the trust is in purple, and this name of the trust is very important. And you'll hear me talk about this in the consultation, because when it comes to creating an actual trust and having your children be able to inherit the things you own and become the administrator of the trust, as an example, if you have a title to your vehicle, if you have the title to your home, chances are the owner is listed as your individual name. In order to put it in trust, you have to go to the recorder of deeds and change the owner's name from your name, your parents' name, your grandparents' name, to the owner of the trust name. So right here it says Felicia's estate. So that was the name of the trust that we had established at that time, because we were protecting this estate of my parents. So that's what that's for, and that's important for transferring ownership from individuals to the trust, so that way your family can own it in perpetuity. So that's what this is. It was recorded on the Providence Recorder of Deeds, and that's what you'll see here on this next thing. Let me do this. that. It'll pop up eventually. There we go. I think it's kind of hard to see. Let me see if I can change this. See if I can make that better. Probably. Maybe. I'll do this right here. And I'm just trying to fix it for everybody so you can see it better. All right. So here's the receipt from the Providence Recorder of Deeds. And again, when we read the Holy Quran by Prophet Noble Drew Ali, it specifies that a true mastermind shows you his footprints to prove that he's been there, and a block of wood can point the way. And I'm specifying this because it's very important that you know that I have experience in this, which is what the consultation is for. If you don't have experience in it, I might be able to help give you some information regarding the philosophy and purpose of trust. So that way maybe for educational purposes it'll help you make better decisions for how you want to administer your estate. And the best way to do that is to get information from someone who's done something before. So here I have circled the Providence Recorder of Deeds, City Hall, Providence, Rhode Island. So you see that I've actually done it. And then under it, you see the trust number. So under this clipped receipt that says unit and price, because I'm hiding private information, because it had my mother's address on it. Under that, you'll see where it says trust, and then that is the trust number. So it's the same numbers. Let's see if I do this. It was the same numbers that I had highlighted right here. The docket number, the book number, and the page number. Now, the reason why we did this, and I talk about this in detail in the live video I did with my parents, was because when we were fighting the foreclosure process, since my name is not on the mortgage, I essentially had no say in the foreclosure process because I wasn't a party to the contract. But when you look up Black's Law Dictionary, you look up the definition of mortgage, some states regard mortgages as a mere lien, which means the bank isn't the owner, and the people that live in the house are the true owners of the house. In other states, it's not. It's more of the old feudal way that they were doing property, which it's still the same thing. I don't want you to be confused by what I'm saying. It's still feudal, and it's still wrong because they don't even live by their obligation of the mortgage. But anyway, I wasn't a party to the contract. So eventually, a few months later, the bank called on. They're saying, "Who's this Jamal guy that keeps responding to us?" And they were getting upset because the things I was saying, it was very hard for them to do what they wanted to do. So they ended up writing a letter. At first, everything was addressed to my mother. Then they started addressing things to my father as if I don't talk to my dad. And then they wrote to my dad that, who's this guy? Basically, this Jamal guy has no claim or interest within this foreclosure process. So that's why we created this deed of trust, this deed of trust, and we declared it on the public record and sent it to the bank, proving that I have interest in this matter and power of attorney. But I'm not an attorney. I'm a trustee of the estate, right? But for colloquially, that's what it would be called, power of attorney. But as the administrator of the estate, I have first-party interest in it now because both parties of the mortgage gave me this ability, right, as their heir. So it would be the same thing as if my parents got an attorney, but instead it was their son. It's the same thing, and this is what wealthy people do. This is why you'll often see wealthy people have their children go to some type of law school because their children are going to be the next successors and administrators of their estate, so they would have to know law. So that's a stipulation that you could put in your trust, and you could put fiat aside to ensure that your children go to some type of law school or take estate classes, so that way they're competent in handling the affairs of the state for whatever issue may pop up, such as a foreclosure, which is really estate embezzlement. And I go over this in detail. There's another part part of the Trust Law series on my website, riseofthemoors.org. When you go to books and literature, you scroll down, there'll be a mortgage fraud, how to stop a foreclosure, Bay versus Oldfield. I go over the federal lawsuit I filed to help fight against this foreclosure process. And I show you the laws from the United States Code of what embezzlement is, because that's what they do. That's what they're doing. They're embezzling your estate in the name of foreclosure. And I explain that in detail in that video. In the video, it used to be really expensive, but I made it $20 now, because this is people's lives and properties we're talking about. I don't want to make their burden worse. Most of the time, or over the past, the people that I've spoken to, they called me, unfortunately, when it was too late, when the foreclosure process was already happening. It's best to have this information and to know this information before you're in trouble. And and I talk about this before in a lot of my live videos. This is what got me interested in more science, being able to protect my loved ones in the future. At the time, I wasn't going through anything, but I already knew, based on the color of our skin, our status in this country, and the occupiers on our land, I already knew I was going to get into something eventually, because that's what the statistics show. If you don't submit to their oppression and their colonization, eventually they will do something to you under the color of law. And that's what happens. So we have to be aware of our situation within this colonial government, and we have to be able to protect ourselves, at least intellectually, until a different time comes. And I'm speaking biblically, where in Ecclesiastes they say there's a time for everything. But anyway, that is available on the website as far as what estate embezzlement is, which is what they were doing. They try to say I had no interest in this process, but I'm their son. So if you take my parents' house away, you're taking my inheritance. So I do have a say in this, right? And I'm of the age of majority, and I'm mentally competent enough to understand that relationship, which proves that I'm competent enough to have a say in this matter. So that's why we did what we did, right? And this trust number was sent to them. And the last thing is this. Let me make this bigger. That's my daughter up there complaining. Let me do this right here. Do that. There it is. So this is, it says right here, State of Rhode Island, Superior Court, Deutsche Bank, which is a German bank, which this issue should have heard in federal court because the plaintiffs aren't even citizens of the United States, right? And obviously, Moors aren't citizens of the United States either, so either way, there's a diversity claim. But literally, Deutsche Bank is a German bank. It's headquartered in Germany. And I put that, I already filed all that. I already talked about all of this in the live video I did with my parents. But this is the result of what happens when you file a trust and adverse claim on the record, right? So you see that, you see my mother's name in purple, you see where my parents are the defendants, and where Deutsche Bank is the plaintiff. And in the plaintiff's own claim, after they foreclosed on the house, this is what they said. Now, I talk about this in a live video I did with my parents. When you claim your estate, that is a lien, right? When you look up what a lien is a claim of interest in something, most of the time for some type of monetary compensation. This wasn't necessarily about monetary compensation, but it was still a claim on property. It was still a claim on something, meaning a claim on property. And the property in question was what the claim was on. So a lien or a mortgage is a claim on the property. So is declaring that this property is part of my estate. And there was a video on some Moroccan soccer player who had all of his stuff in trust. And his wife tried to divorce him and take all his property. But guess what? It wasn't his property. It was held in trust for his family, so it wasn't his. So she couldn't take it, right? And to kind of make it simpler, if that's not simple enough, like when we hear stories of drug dealers, they always put property in like their children's name or their mother's name, so that way if they get booked, the government can't liquidate their assets, can't take their assets. That's the same thing, but instead of putting it in your mother's name, you put it in a trust name and you make your mother the administrator, right? Same thing happened with one of the Kennedys, I believe. He was drunk driving, hit someone, and then called his family, and his family said, "Come home right now." And they immediately put his things, all of his assets, in a trust. And then when he went to court, they couldn't liquidate anything. They couldn't take anything because it was protected by a trust. There was a claim already made against all of his assets, and the claim was essentially made by the heirs, the future heirs, on behalf of whoever the grantor was, right? Which is supposed to be you or your grandparents or your parents in this case, right? And this is how generational wealth is created, and this is why we don't have generational wealth, because most of the people I've known who's part of my bloodline and or people that look like me, if we want to go the colorism route, they don't know anything about trust. And that's why we're in the situation that we're in. And of course, the rap music that we listen to, oh, you can't take nothing with you, so blow it all. That is terrible advice, because most of them have trust and estates. You'll see the estate of so and so, or like in a wrongful death, you'll see the estate of the deceased suing someone, because that's what an estate is about. It's about the entire family, future descendants, and everything that the family owns. So, since a claim was made on the property before the foreclosure process happened, pay attention. Before, before, before the foreclosure process happened. When they foreclosed, they couldn't sell the property. Why? Because when you put a lien on a property, you can't sell that property or liquidate that asset without doing what? Paying the primary lien holder. So they couldn't have sold the property without paying who? The people that they foreclosed on. Do you understand that? So they tried to embezzle the estate from my parents. They went through the process. They even had people come look at the house and everything. But as if any one of you is a property owner or has ever been to the recorder of deeds, everything is there. That's why we put this in the recorder of deeds under the name of the property in question, because whenever this is supposed to be common knowledge, right? Whenever you look at any property, you're trying to buy it or sell it, whatever, all of that information, all the liens that have ever been on the house is there. And if there's anything that's not paid off, when you sell that house, you have to pay that off. So they couldn't sell the property after the foreclosure process. Which means what? Well, I'll read it to you. And this thing's deliberately hidden because I don't want you to know where my parents live. Right. You'll see right here. Plaintiff files the instant complaint to rescind the foreclosure sale and revert ownership of the property to the defendants, and to extinguish the foreclosure deed. So there it is. Deutsche Bank. And this information is available when when you just go to riseofthemortals.org, when you go to the website, you'll see that you'll see as part of the images attached to the consultation link, if you want to call it that, whatever you want to call it. Those pictures I just showed you are available, showing like exactly what it just said, that they reversed the foreclosure and they reverted ownership of the property back to my parents because we did what we did, not because they said, all of a sudden we're just gonna reverse a foreclosure. When have you ever heard of that? I've never heard of that until this case, until the situation with my parents. I've never heard in my 30. Jojo! Jojo! I'm 31, right? I'm 31? Me! In my 31 years of life, I've never heard, ever, of a reverse foreclosure. And I've had Moors contact me from across North America, telling me about how, hey, my grandparents own this property and now these people are trying to take it. And I gave them information. I don't know what they did, because again, Rise of the Moors does not give legal service. We give information for educational purposes only. I don't know what they did with the information, but no, only a few people have called me back or messaged me back saying, hey, you helped me with this information, save my house that my grandparents owned. And actually, while I was in jail, there was a lady that ended up donating some fiat, because of that very thing. I never even met the lady. I don't even think I spoke to her. I think she just purchased something on the I think it was my Trust Law series or the Bay versus Oldfield case, and she said that she ended up saving her estate, which is great, because we already know that these people will call the sheriff and throw a whole family out during the wintertime, even though their own state law says you can't do that, but they do it anyway. So it's great when Moors use information to defend themselves, as opposed to getting a consultation from an attorney that's going to cost them $500 just to talk to them, let alone going to court and advocating for them, which we already know. Corpus Juris Secundum, I think it's volume 7. When you look up attorney, their first obligation is to the court, which means what? Their first interest is the court, not you. It's the court. So whatever the court is doing, which again, the court includes whoever's sitting on the bench, the so-called judge, the prosecutor, and the defense attorney. All of them are the court. So yeah, they're not gonna unless you give them fiat. Right? And I was actually talking to Jalil, I think it was yesterday. Yeah. And he was telling me about how someone he knows said that the most money is in family court and estate court. And depending on how wealthy the person is in estate court, they can prolong the court hearings through continuances and get paid from these people. Because most of the time when you're talking about estates, you're talking about people that have wealth. So they're able to, prolong things and charge them a ridiculous amount of money. Also, trusts help avoid probate. Now, probate, or the court of chancery, sometimes they call it, probate court, the word probate means to prove. So when someone's on probation, they have to prove where they are all the time. They got to check in with a whole grown adult and say, hey, I'm here, hey, I'm home, blah, 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 blah. So probate court, normally what happens is sometimes and this is why creating a will is not the complete process. You have to have a will, an estate plan, and a trust. Well, part of the estate plan is to have a will and a trust, to be clear. So when you have a will, sometimes the parties who are inheriting whatever you have in your will, they argue, well, I want this. Why do you get that? Blah, 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 blah. And since they're relatives and they're disputing with each other, most of the time relatives don't know how to settle disputes. So guess what they do? Now they have to get a third party involved, being the court, which means what? Now you have to pay for lawyers. Now you have to pay the court for them even getting involved, even though you allegedly pay taxes to run the government. So you shouldn't have to pay them anything because it's already coming out of your paycheck, and sales tax and property tax and excise car tax and toll tax and employment tax. So anyway, um, so now you got to pay. Now you have to pay attorney fees and probate costs and court fees. Right? That's what happens when you don't have a will. I mean, when you don't have a trust, because in your this is why they call it a an expressed trust, because you're expressing what you want to happen when you die, and you're expressing who you want to have what when you die. Of course, something similar is done in wills, but it's not a trust. A will is just handing out assets to whoever, and then that's the end of it. When it's in a trust, the asset isn't always distributed to individuals, it's still held collectively in a trust. And sometimes there is a fund available for specific purposes, such as college, maybe, or annual trips, or a trust fund for some type of stipend per month or per week or per year, or whatever. Again, the trust can be as detailed or as short as possible. And these are the types of things that trusts avoid. But what's also worthy of note, again, is being competent, because during this foreclosure process, Deutsche Bank, who their headquarters is in Germany, they already violated the Rhode Island law, because during the foreclosure process, according to the statutes of Rhode Island, there's a arbitration. There's a state law that requires arbitration before the foreclosure process can even happen. So that's supposed to be when the bank allows you to say, hey, I can't afford this type of payment, but I could afford this type of payment. So if they even want to hear it, so that's what the process is for, arbitration. Uh, Thank you. I miss y'all too. And again, just going back to the mortgage and what a foreclosure is. When you look up the definition of closure, you'll see in Black's Law Dictionary, or you just Google it and Google legal definition of closure, you'll see that a closure only happens once a contract is signed, right? So when you sign the mortgage, that is the closure. You closed there's no more time for negotiation. It's closed. The deal is closed now. That's why it's called a closure. You're closing the terms of negotiation, right? You're closing the window of time for negotiation, and what you put your signature on is closed now. It's final, right? So a foreclosure literally means before the closure. So how can you do something before the closure after the closure? That's like saying I'm about to do something at 7 years old. I'm 31. How could I do something right now at 7? Or before 7? It's already done, right? So that's the fraud in that. And that's where it becomes estate embezzlement. And then again, when you look at the terms and conditions of the mortgage, the bank promised to give you 200,000 or whatever it was, and they never did. In fact, they're only required, according to the federal banking policies, they're only required to have 10%. So they never even had the full 200,000. They only had 20,000 max, and then they didn't even give that to you. So how is it that they're faulting you for breach of contract when from the beginning they breached the agreement? They never even gave you anything. And this is why you see within the fair debt collection process of the United States federal law, part of the Fair Debt Collection Act is for them to prove that the federal government requires that any creditor alleging to have given you any money, before they can say that you owe them anything, they have to prove that they gave you something in the first place. So before they can file a claim that you didn't pay them X, Y, and Z, they have to prove that they gave you X, Y, and Z, which they don't. They show you a contract that they didn't sign, a unilateral contract that they didn't sign, which means they didn't agree to anything, where you agreed to pay them back, but you never received anything. So how can you owe someone something if you never gave them something? You can't. This is where it comes estate embezzlement, because they're declaring themselves as a trustee and they're trying to take your property. That's estate embezzlement. Now, is an attorney who's an officer of the court going to tell you that? I highly doubt it. Is the judge going to tell you that? I highly doubt it. Is the prosecutor going to tell you that? I highly doubt it. But guess what your obligation is if you're dealing with these issues? Your obligation is to bring it up. This is where competency is very important. And uh, again, I was talking to Jalil yesterday, and eventually we're going to do, or we talked about planning to do more talks on these types of topics. But just to break down briefly what a mortgage is. A mortgage it consists of sometimes three separate documents, but all of it is called the mortgage, colloquially, right? So you have one, the promissory note. The promissory note is exactly what it sounds like. Someone is promising to do something, right? And a note is a reminder. So it's just a contract saying that this party gave that party X amount of dollars. And the borrower promises to pay back that money. That's the promissory note. Then you have the lien, or the security instrument, or the mortgage. So those three things are the same thing. The lien is the mortgage. The security is the mortgage, or the securitization of the promissory note is the mortgage because it's a lien. So what the mortgage says is similar to the promissory note, that the bank gave you X amount of money. If you don't pay that money, this is the security on the behalf of the bank. So the bank is secure either way. They never gave you any money, and if you don't pay them back, they get something worth 1,000 times more than what they gave you, which was nothing. So this is where they're securitized. They have security. Like if you loan someone $5 and you're like, dang, I don't know if they're going to give me back, you're not secure, right? But if you loan someone $5 and you say, okay, if you don't give me my $5 by Monday, you agree that I get your iPhone on Tuesday. Now you're secure because chances are they want to keep their iPhone, right? So that's what the securitization is. It's securing the loan. But who becomes the secured party? The bank, not you. Now you might have the feelings of security because you have this house, but in feudal tenures, it's not yours. Anyway, that's what you have: the promissory note, and then the mortgage itself. The mortgage itself is just securitizing the loan, and in it, it specifies if you do not pay this back as collateral, the bank gets the property, right? And in that, you have the property in question, the parties, meaning you and whoever loaned you the money allegedly. Then you have the governing laws of that contract, which it just is very general. It says all applicable state and federal laws, which in the Nick Bay versus Oldfield federal court claim that I have available on the website for $20, I read everything that I filed with the federal courts challenging this foreclosure, which was a state embezzlement. And I read within the mortgage itself where it talks about the governing law is all applicable state and federal law, which is how I knew that it was their obligation to have an arbitrary claim, have an arbiter involved before we even go to the foreclosure process. This is why reading the mortgage is important before you even sign it. But I already know most people don't read it because they're first time homeowners. They're probably early 20s, or maybe even, it doesn't matter their age, they were probably never taught to read documents. It was just you sign here because you got a real estate agent and they're doing their job for you. So you created a trust with this person you don't even know, the real estate agent, who you think had your best interests in heart, and they don't. They're just getting a percentage of this deal. And you got screwed in the mortgage agreement because you didn't read it. So read it. If you have one, read it. If you're about to sign one, read it. If not, hey, read it. Anyway, so you have, again, list of the parties, the property in question, the amount in question, governing law, and then you have an important part, and this is what Jalil and I were talking about. One of the main important parts, besides the governing law, is where the banks often reserve their right to collect the loan amount in full at any point in time. So you think you signed this 30-year mortgage. You think that this document is legitimate for 30 years and they can't do anything unless you default. And if you pay it off within that 30-year time period, then it's yours completely. But you did not read the part where the bank says we reserve our right to collect the payment in full at any point in time, whether you defaulted or not. Now, you may be thinking to yourself, all of this seems unfair. And you're right. But guess what you have the ability to do? Negotiate. And this is again where mental competency is worth the world's weight in gold. So that way you can challenge a lot of these things. Because as an example, when we're dealing with arbitration, to avoid going to court, you can specify that you want to choose the arbiter or arbitrator. I think both words are correct. Who knows? Not me. Anyway, you can choose who you want to be the arbitrator. And what if you chose a Moor? What if you chose a Moor to arbitrate this process? Now, of course, you would have to prove that there's no third-party interest and you don't know this person personally and things like that, obviously, to be fair. But if there was Moors out there that were creating these services and new law as opposed to just rapping and making music videos and providing professional arbitration services, we could change a lot based on the law, right? But anyway, you have the bank reserving their right to do whatever they want. You didn't read it. And then you're the only person that signed it. Or, your spouse also signed it. And then, of course, you have the interest amount, fixed or variable. And you have the bill of particulars showing how much you're actually paying towards the loan, how much you're paying in taxes, how much you're paying in for escrow and things like that. What's also worthy of note is when they sell mortgages. So the bank often, one, never gave you money. Two, only had 10% of what they said they gave you. Three, collects a few payments from you, which means they just made a profit. And then three, sells the mortgage to someone else. Now, just for basic, I'm going to keep things basic. I'm not claiming that these are the numbers that they sell it for. But now imagine you're the bank, right? And federal law only requires you to have 10% of what you're claiming to loan. So let's say you're loaning out $200,000. You're only required to have $20,000. Now, if so 5, 10, 15, 20, if you and four other people put together $5,000, you have $20,000. Then you could be a bank and loan out $200,000. You only have $20,000. Now, in credit, you don't give anybody that money. So then, and this is exactly what the banks do. So they give out this loan of $200,000. They only have $20,000. Your monthly payment to the mortgage is, let's say, $1,000. They keep you in the house for a year before they sell the mortgage. They just made $12,000 off of you, hard cash. Then they sell the mortgage in the secondary market for, let's say, $50,000. So they just made $50,000 plus the $12,000 you just gave them, and they only had $20,000. How much money is that? How much money did they just make? What's $50,000 plus $12,000? $62,000 they just made, and they didn't give you a dime. Now, in equity, when they sell that mortgage for 50,000, according to equity, that 50,000 is supposed to be taken off that loan. So instead of $200,000, there's $150,000 that you owe. But guess what they don't do? They don't do that. Which is fraud. And of course, if you follow me on Instagram, which you can follow me on Instagram by going to riseofthemoors.org, and on the homepage, you'll see the Instagram, YouTube, and TikTok. I talk about Fannie Mae and Ginnie Mac, or whatever their names are. It was the United States federal government creating a secondary market for mortgages to buy and sell mortgages, which is exactly what they did, and they do. And I connect it to how, when a few months ago, how there was, that cryptocurrency where these people were creating fake markets for these coins. They were just selling it. Let's say it's, you, me, and 5 other people. We create this coin that's worth a penny because nobody knows about it. And then I'm your friend and I say, yo, I'm going to buy this coin for $1. And then our other friend says, oh, I want to buy that coin for $3. So now we're creating fake value in this fake crypto market where it had no value. It's not worth anything. But we're making it seem like it does, but we're just a group of friends. And then other people see this trade happening on this crypto market, so they think it's real. So then they say, oh, that coin just went from a penny to $5 within 2 days, even though it's 5 private friends buying it that they don't know about. So now the perceived value is increasing, and then more people buy into it, and then guess what those 5 friends do? They cash out. They take all the money out of the market, and now the people just lost everything. And that's exactly what they do with mortgages in the secondary market. This is why that whole AAA rating, the B rating, the C rating, whatever, caused that market crash in 2008, because that's exactly what they were doing. So, how do you protect yourself? 1, competency. This is why Morris constantly and consistently should be talking about status, and how status is nothing more than mental competency. So your mental competency will change your status from victim of these processes to being able to not be a victim in these processes and defend yourself. That's what mental competency is. That's what status correction is. You're changing yourself from incompetent to competent, and in that process, which cannot be explained in words, you should no longer be a victim. That's on an individual level. And then on a national level, we're supposed to work together and work with each other to help to ensure that our assets and our states are protected. And this is why Prophet Noble Drew Ali said, if you're going to buy property, put it in the name of the Moorish Highness Temple of America, or put it in the name Prophet Noble Drew Ali, because when you put your property in the name of an organization, and that organization is a civic organization or a religious organization, you get tax benefits from that. And then if someone's trying to take your property, now you have this entire organization and its competent leadership helping to protect your asset, as opposed to just you not knowing what to do. And then now you got to pay an attorney and you're already broke because you're already in poverty. No. That's what the organization is for. And the leadership of the organization is for. And that's what Rise of the Moors has been trying to do for a long period of time. But for some reason, Moors aren't interested in that. And that's okay. Because I'm still going to protect my loved ones. And that was proof of that. This right here is the proof of just that. So whether you're involved with Rise of the Moors or not, I will still continue to do my best to provide for my heirs and protect my estate and the estate of my loved ones. I'm just trying to give information so Moors can do the same for their loved ones and for themselves. But whether you do that, that's up to you, not me. So again, information is available on riseofthemoors.org. There's a free video on our YouTube on trust law. We have the trust law 101 through 104. It's a whole series on the website available for you. And then we have the Bay versus Oldfield case where it's a real federal case where I was challenging the foreclosure process, and I believe that also had much to do with this reverse foreclosure that the bank. Actually, let me leave that up. Let me leave that up, just so you can see that. Let me make that bigger. Oops. I got a lot of stuff in the way. Yeah, I put it right there. Just so you can see. I kind of lost track of what I was saying. Something about trust. Oh, so you can see for yourself that I'm not just blowing wind out of my orifices. This is a real life situation where it was nerve wracking. I talk about this live in a video how I just hated to see, the anxiety and the pressure that my mother was under, what my parents were under. But, specifically your mother, your dad is your dad. And, my dad's like 6'4", 200 and something pounds. So, he's a big boy. So I was a little less concerned for my dad, than I was for my mother. And that is a natural thing. I was inside of her womb for 9 months. So I'm more connected to her than, and this is normal for everybody. Obviously, everyone knows that. I'm not disrespecting my father. But it just hurt me to see my mother in that type of pain and stress and worry and concern. And it kind of invigorated me to, fight for, I was inspired with that holy zeal, like the Quran says, to defend my mother. And I feel like that is our obligation as men to protect our women. And what better way to do that than to protect, their estates. And obviously, I believe in Islam, so it is a religious requirement for me to be the protector of the women in my family, all of them. So I feel like I was just doing my job. But I don't like that my people feel helpless in situations like that. And obviously, especially my mother, I didn't like that she felt helpless and she felt like, we moved into the house in 1999. Before that, we lived in the projects. We lived in the projects in Pawtucket. The Heights is what we call it. I don't know the official name of it. The Heights is what we called it. I think we lived in the Manor too. All right, I think we lived in the Manor too, which is just another project in Pawtucket. Then we lived in Astoria, Queens, with my aunt Janie, who's Janae's grandmother. It was a 3-bedroom apartment with my aunt Janie, me, my mother, my sister, and Stephanie, who's Aunt Janie's daughter, my cousin Janae's aunt, in a small bedroom apartment in Astoria, Queens, New York. Then we lived with my grandmother on my mother's side. Then we lived with my grandmother on my father's side. And then we got into this house in 1999. So there's a lot of sentimental value in this house that we lived in since 1999. And I'm glad to say that my parents still live there to this day, right now, July 5th, 2023, because of the information that Moorish science offers, and the science of law and the science of equity and the science of estate planning and estate law. And I want every Moor to have this information too, so that way they can defend themselves where an attorney won't. But my wife has to do something. As you can hear, my daughter is having fun upstairs, clearly. So I got to end this video and tend to my daughter. So thank you for your time. Hopefully you learned something. Please visit riseofthemoors.org if you're interested in this consultation service for you to get more information about estate planning. And I have a resource for you regarding trust law. It's a third-party resource. It's not from me. Please get my Trust Law Series 101 through 104 on the website riseofthemoors.org. It's not a smoke battery. It's my alarm. And it just does that. And it's wired into the house, so there's not a battery that needs to be changed. Oh, she's coming down. Hi, baby. My baby. Mwah. I love you. So sweet. Mwah. Um, yeah, I'm about to get off anyway. Um, get it? The consultation service is there. There's disclosure information in the description of it, and of course, all of it is subject to the legal description and disclaimer at the bottom of my website on every single page. Go to riseandmores.org. There's a lot of information for free. I'm about to upload another 22-page document to the website for free regarding Lot and Moab and the Aramaic language, Phoenician language, Moabite language, Arabic language, the Hebrew language, and just more information about Moab and who we are as Moors. Thank you for your time. Let me see if there's any questions before I go.
She said walk dirty, and then she said feet.
Hi, baby.
She's getting closer.
It's so cute. Oh, the camera's high. She won't be able to be in it. Mm. See the comments.
Chop.
Peace. I appreciate the glad to see you comments. Jail sucked.
Bus. Where did you see a bus?
Peace. Peace.
Two chalk. You have two pieces of chalk. I'm gonna move to the basement. Okay?
All right. Let me see. I don't see too many questions.
3.
General question for everybody. I miss y'all too. Someone said we have to study security. Security is not that complicated. It's just like I said. Excuse me. It's in the word. What makes you secure? What in your agreement is going to make you a secured party? It's not that complicated. And I've said this for a few years. I've been saying this for a few years. That a lot of Moors, and I'm not saying the person who wrote that comment is doing that, but I've seen a lot of Moors try to make it seem like securities is some complex thing, and it's not. An insurance policy is a security instrument. You're secured for whatever insurance that covers. Car insurance, you're secured knowing that your car is covered. That's all securitization is. Period. And it applies to anything. Your house. You can secure your house. You can secure your shoes. You can secure your computer. You can securitize your laptop and your TV, and you can securitize anything. So don't think it's this complicated process. It's all in the writing of whatever agreements you enter into and your trust. Should we copy word for word your works? No, because some things I have are specific to me. Like as an example, the declaration of trust that I created with my mother was very specific to our situation. Now, can you use some of the language in it for you and your parents or whoever you're trying to enter into agreement with? Absolutely, you can, but know what it's saying. Don't just copy what it's saying. Again, mental competence is worth way more than the earth's weight in gold. She's walking upstairs. Stay down here, baby. Good job listening. Nah, she's coming back down. She only took 3 steps. Good job, baby. You're so brave. Yeah, so no, stay down here, baby. Everything that I've written, of course, anything that I make public, you can do whatever you want with it. Anything you want. I don't care. Uh, Please don't slander me though. And if you do, I have the right to sue you. So I don't want to I don't want to be general. You can do anything. Most of the things I do are for educational purposes. Even the things that I've actually applied in my real life, use me as an example. By no means are my documents supreme or the best or absolutely perfect. You said climb up? No, baby. We don't want you on camera. You're too beautiful. So you can use my stuff and study it, and if you want to use it without reading it, that's up to you. I don't recommend that, but you can copy what I have word for word. But again, everything on Rise of the Moors is for educational purposes only. It's not it's not used to encourage you to do anything. It's for you to read and study. No, no, I'm not saying you're gonna slander me. I'm speaking live, and this is gonna go on a public forum. So I'm saying generally, because let's say someone does slander me and they say, "Well, he said I can do anything." That's not what I meant. That's why I'm clarifying. uh, yeah, most of them are in violation of every single law that exists. But anyway, yeah, use what I have to study, and whatever actions you take, that's on you. Again, none of this is legal service. It's the disclosures are there. Um, but yeah, you can use everything I write in whatever fashion and form you see fit, so long as it's not detrimental to me, my image, or my loved ones. And if you make money, then I'm entitled to something that you make off my image and my intellectual properties. Know that. That's in my trust, and I have to enforce that because I have to worry about my children's future. Because they own all of my intellectual properties when I'm gone. So if you're using it and making money off of it, they have first priority claim to sue you. Just know that. And even if you didn't know, it's still in the trust anyway. So thank you for your time. There's a lot of free information on the Rise of the Moors. I went over some of that in the last live I did called Free Information. I'm going to add something else. Again, it's a 22-page document. I might be able to show it. Hold on, let me see. Let me see. I just have to add this. It's going to be on the website, so it doesn't matter that I show you what just happened. I don't know why it turned black. Let me see. What is it? Not window capture. I think it's window capture. It might be window capture. Display capture, maybe. Let me see. Automatic. Nope. Yeah, I'll just do this. We'll see. I might have to do this. Yeah, okay. This is complicated. I'm pretty sure there's an easier way to do it. I just don't know how to do it. So we will do this. You can see everything I see now with this transition, I'm pretty sure. Yeah, there we go. So this is what I'm working on. I know you can't see my face. Actually, let me fix that so you can see my face. Boom, boom, boom. All right. This just says Lot in Moab in Arabic. As you know, as most people know, I've been studying Arabic. And then I talk about why I'm writing this. That's what the abstract is for. Then I go into some things that can be said about Moab. I talk about, they're under the Assyrian Empire and transitioning to the Persian Empire. How, Moors were still still known under the Assyrian Empire. And once Babylon or the Persians came and Moab tried to form a coup to overthrow them because of their oppression. Um, that's where I state the idol worship came into play because, when we talk about who Moab is, who his grandfather is, and um, who the uncle of Moab's grandfather is, and where they came from, then we clearly know that Babylon in Mesopotamia, the Persians, practice idol worship. We know that for a fact. And it's in Lot's uncle's story. It's in his story. And if you don't know who Lot's uncle is, which you should know, as a Moor, you should know, the answer is right here, Abraham. Abraham is Lot's uncle. Lot is the grandfather of Moab. According to our prophet, we are the descendants of Moab. Just like the Arabs are the descendants of Hagar or Hagarites, which Hagar is the mother of Ishmael. We are the descendants of Moab. Now, briefly, Abraham, obviously a prophet of Allah, broke the idols that his father was making. The entire community tried to murder him. They catapulted him into fire. The fire didn't burn him by the permission of Allah. And once he walked out of the fire unscathed, guess who said La ilaha illallah? That's right, Abraham's nephew, who? Lot. And since then, we're told that Abraham was told to leave with the believers. Who was one of the believers? Lot. According to some narratives, Lot was literally the only believer after Prophet Abraham. But in Prophet Abraham's journey out of Babylon into Egypt, he came across this king, who the king said, "Well, I am God. What's so special about this Allah you speak of?" And Abraham said, "Well, the Allah I worship, who is the creator of all things, including me and you, makes the sun rise from the east and set in the west. If you are God, make it rise in the west and set in the east." And he couldn't do it. So he kicked him out. Lot would have been present for this when he seen the people worshiping stars. And he tried to appeal and relate to them, saying, "Oh, wow, look, I found this special star. That's my God." And then by the time the constellation was no longer visible, he said, "Oh, man, that can't be my God because I can't see it anymore. I don't like things that set. That can't be my God." So the people are like, "Oh, wow, yeah, he's one of us." And, that makes sense. And then the moon comes. He says, Abraham says, "Oh, behold, I see something even better than that last star we just seen. The moon, it's so beautiful and big. I know, that thing must be my God. Please don't dump this on me." Your hands are dirty? Hands are dirty. Good job, baby. He said, "Oh, look, the moon is my God." Of course, Abraham is going through this process to teach people how the sun and the moon and the stars are not God. Right? He didn't actually believe that. It was just for teaching purposes of these people. He was trying to relate to them. And then the people said, "Oh, yeah, look at the moon. It is bigger. It is brighter. That must be our God." And then the daytime came. And then Abraham, teaching said, "Oh, man, that can't be my God. I don't like things that disappear." And then he said, "Oh, behold, the sun, even brighter and bigger than the moon." Labogano. And then the sun set. And Abraham said, "Wow, the sun, moon, and stars can't be my God because when it's daytime, the moon's not out and the moon can't hear me because it's gone. When it's nighttime, the sun's not out, the sun can't hear me when it's gone. And when it's daytime, the stars are gone. I can't see them, they can't see me. So I don't worship things that can't hear, see, or listen to me." Or hear, same thing. And that was, and Lot would have been present for that as well. Up until their journey into the land of Canaan, where they separated, and their herdsmen argued according to the narrative that is in the Torah, which in the Quran it specifies that we're supposed to acknowledge and honor the Torah and the Injil, which is the gospel. But we know that those present books are altered in Islam. We believe that the originals are lost. But the stories regarding the existence of these prophets are real and they're confirmed in the Quran. This is why, in one of the verses in the Quran, it specifies, "Amanna billahi wa ma unzila ilayna wa ma unzila ila Ibrahim wa Ismail wa Isaac wa Yaqub wa al-Asbati wa ma utiya Musa wa Isa wa ma utiyan nabiyyun mirabihim la nufariqu bayna hadin minhum nahnu muslimun." We believe in Allah and what was revealed before. Wa ma unzila ilayna, what was revealed before or onto you, meaning Prophet Muhammad, and what was revealed to Jacob and Abraham. Well, Abraham and Jacob and Isaac and no, don't touch your head, baby. And the tribes and what was given to Moses and Jesus, we make no distinction between any of them, and unto Allah we have submitted. So, if you claim to be a Moorish American and you claim to follow Prophet Noble Ali, who said we honor all true and divine prophets, you have to acknowledge that these things, these things are real and these things happened. So you have to believe in this story. If you don't, then you can't profess to be a follower of Prophet Noble Ali. And then you can't also claim to be a descendant of Moab, because you have to acknowledge that Abraham is real in order for him to be Lot's uncle. And then you have to believe that Lot is real in order for Moab to exist. So you have to believe in these things. But anyway, Lot would have been present for all of this. He would have seen all of this, right? And I explained why that's important because of the claim, several claims that Lot fornicated with his daughters, which he did not. According to the Quran, all of the prophets are immune and exempt from all of the atrocities that man claimed that they've done. And in the Islamic point of view, I talk about that in my book, Muslim versus Muslim, the story of Moab and his creation, and not as a result of Lot getting drunk. And I also discuss in this right here how the Jews and the Christians don't even think that Lot was a prophet. Some of them even claim that he was insignificant. And then, how... Anyway, I won't go over everything. I'll just make this available on the website. I'll wrap it up with that. Briefly, I'll show you this. The script of the Moors. Anyway, thank you for your time. Hope you learned something. Visit riseofthemoors.org. There's a lot of free information on the website.